Yeah, you scared?
Hmm?
Are you scared?
Yeah.
I saw you biting your nails. Don't be scared.
It is Friday, May 29th. We're here in two cause numbers, 323-112447-19 in the matter of, is it Micaiah Yvette Walden?
Yes, sir.
And then the second cause number is 323-113494-20 in the matter of Micaiah Yvette Walden. Are you Ms. Walden?
Yes, sir.
All right. Pull your chair a little bit closer to the computer for me. Now you just speak up nice and loud. Miss Walden, what is your date of birth?
09/23/05.
All right, and that makes you how old?
14.
Okay. Is there an agreement among the parties regarding the outcome of these cases?
Yes,
Yes,
Okay. Mr. Adeniji, I have before me a document, actually two documents, both have the same title but different cause numbers. The documents are titled State's Disclosure of Documents, Items, and Information Provided to the Respondent. Are you satisfied with the discovery provided by the state in these cases?
yes, Your Honor.
All right. I also have before me two documents titled Waiver of 2 Days. Pursuant to Rule 201 of the Texas Rules of Evidence, the court takes judicial notice of the contents of the court's file and files in these cases. Service in cause number 112447 was service of the motion to modify disposition was effected on May 1st. And in the other cause number, the court's file reflects that service was effected on the respondent on May 20th of 2020. Mr. Adeniji, do you feel you've had enough time to prepare for these cases?
Yes, Your Honor.
Need any additional time?
No, I'm good.
All right. Pursuant to the order of the Texas Supreme Court, the courthouse is generally closed to spectators. However, in keeping with the open court of the Texas Constitution, this hearing is being broadcast on the court's YouTube channel. Ms. Walden, you have an absolute right to have your hearing before Judge Kim if that's what you want to do. However, if you'd like to proceed today in front of me, Judge Porter, you may do so. Do you wish to proceed in front of me?
Yes, sir.
All right, and Mr. Adeniji, you join your client in waiving her right to a hearing before the district judge in both of these cases.
We do, Your Honor.
All right. Ms. Walden, you also have a right, excuse me, to a jury trial in your newer case, cause number 113494-20. And a jury trial would be where a group of people from the community would be called in, a jury would be selected, and the jury would decide whether or not you actually did what the state has accused you of doing. As part of a jury trial, you could force the prosecutor to call all of their witnesses that might testify against you. You would get to look those witnesses in the eye, and then your attorney, Mr. Adeniji, would get to ask them questions to make sure that they're telling the truth. And then at the end of the trial, the jury, not the judge, but the jury would decide whether or not you actually did what you're accused of doing. Do you understand that?
Yes, sir.
All right. Now, with respect to the older case, 112447, in which a motion to modify has been filed, I get to decide that. You don't have a right to a jury trial. You understand that?
Yes, sir.
Now, because that's your right, you may, if you wish, give up your right to a jury trial and say, Judge Porter, I want you to decide everything in both cases. What would you like to do? Would you like to have Judge Porter decide everything in both cases?
Yes, sir.
All right, Mr. Adeniji, do you join your client in waiving her right to a jury trial in the newer case?
I do, Your Honor.
All right. Now, Ms. Walden, I have before me a long document. It's 2 pages. And I have one for each case. The prosecutor and your attorney have already signed off on it, but in order to find out whether you agree with it, I have to go over it paragraph by paragraph with you, okay?
Yes,
A
sir.
couple of the paragraphs I'll read together, and at the end of each section, I'll ask you whether or not you agree with that paragraph or those paragraphs. Do you understand that?
Yes, sir.
If at any time you don't understand or you feel like you want to talk to Mr. Adeniji privately, I want you to wave your hand like this.
Yes, sir.
That'll get my attention or your attorney's attention, and I'll create a private internet chat room for the 2 of y'all to talk, okay?
Yes, sir.
Hold on, I've got somebody in the courtroom. Sorry. Okay, Ms. Walden. And you'll have to be patient with me because I have to read both of them to you, and both of them will sound a lot alike, but please be patient with me. Okay, in cause number 323-112447-19. May it be agreed and stipulated between the parties in the above styled and numbered cause in which Makia Yvette Walden is the respondent the following facts. If the witness, these Owens, were in court and testified under oath, they would testify that they reside at a certain house number on Lincolnshire Way, Fort Worth, Tarrant County, Texas. They would further testify that they are the parent or guardian of the respondent in this cause, that the respondent's name is Makia Yvette Walden, a female child, 14 years of age, having been born on that date of birth you and I discussed earlier. The witness would also testify that they are the person who has the custody and control of the respondent in this case. Do you agree with those paragraphs, Ms.
Yes,
Walden?
sir.
Pardon?
Yes, sir.
Okay. Next paragraph. I, Makia Yvette Walden, the respondent in the above entitled and numbered cause in writing in an open court, consent to this stipulation of evidence, and in so doing expressly waive the appearance, confrontation, and cross-examination of witnesses, the right to a trial and the right to a trial by jury, and further consent to the introduction of testimony by affidavits, written statements of witnesses, and other documentary evidence. Accordingly, having waived my federal and state constitutional right against self-incrimination, and after having been sworn upon oath, I judicially confess to the following facts and agree and stipulate that the facts are true and correct and constitute the evidence in this case. Did you understand all that?
Yes, sir.
All right, do you agree with all that?
Yes, sir.
First numbered paragraph. I was born on that date you and I discussed earlier, and I live in Tarrant County, Texas. Do you agree with that?
Yes, sir.
Next, I was placed on probation in this case for the felony offense or offenses of assault public servant. I agree and stipulate that the court gave me certain terms and rules for the probation period that included the following. I was ordered not to run away or live elsewhere without permission of my parents, guardian, and probation officer. I was ordered to obey the rules of the person responsible for my custody and to not violate any laws. Do you agree with that paragraph?
Yes, sir.
Next, I agree and stipulate that I have violated my probation by paragraph 1, on or about the 9th day of April 2020, I committed the offense of unauthorized use of a motor vehicle. Do you agree with that statement?
Yes, sir.
Next one, paragraph 2, on or about the 3rd day of April 2020, I ran away from my mother's home. Do you agree with that?
Yes, sir.
Final paragraph. I, Micaiah Yvette Walden, further agree and stipulate that I am a child in need of rehabilitation, or that the protection of the public requires that disposition be made. I stipulate that it is in my best interest to be placed outside my home. Reasonable efforts were made to prevent or eliminate the need for removal from my home. Reasonable efforts were made to make it possible to return home, and the quality of care and level of support and supervision needed to meet my conditions of my probation cannot be provided in my home. I further agree to a disposition of extension of my probation for a year, placement at Lake Granbury, and any other orders of the court. Do you understand that paragraph, Ms. Walden?
Yes, sir.
Okay. Do you agree with that paragraph?
Like with the probation I do, but then with the placement, it's like I have a lot of reasons why I feel like I shouldn't go to placement.
Okay, but what's going to be best for you?
It's not placement because I've been doing good in here. I've been here a long time, and I feel like I'm able to control myself.
Well, is this the agreement that you reached with the prosecutor and your attorney?
Yes.
Okay. And you understand you're on probation for a felony, right?
Yes, sir.
Okay. Do you understand what my options as the judge in this case are?
Yes, sir.
They could be as little as, even though you just pleaded true to violating your probation, I could find it not true, right?
Yes, sir.
All the way up to what's the worst possible thing that I could do in this case? You're on probation for a felony. What's the worst I can do for a felony?
Send me the TJD.
Yes, ma'am, it is. Okay. So we got, on the one hand, nothing at all. On the other hand, the absolute worst thing at all that could happen. Okay. Extension of your probation and placement at Lake Granbury. Is that somewhere in the middle?
Mm-hmm.
Okay. Is that less bad than going to TJD?
Yes.
Okay. So you and your attorney worked out a plea bargain with the prosecutor, right? For something less bad than TJD, right?
Yes.
Okay. So do you agree with that, or do you want to break your plea bargain and reset this for a different day?
Oh my God, I don't know.
Do you want to talk to me?
Yes.
You want to, here, I'm gonna create a breakout room and you and Mr. Adeniji talk for a little bit, okay?
Yes, sir.
Okay. Hey, it's gonna be okay. Okay, you should have a pop-up that says, do you want to join the room?
Judge, we're back.
All right. Just waiting. Okay, Ms. Walden. Okay. Ms. Walden, is it your desire to agree to the plea bargain, or do you not agree with the plea bargain?
I agree.
Okay. Are you sure?
Yes, sir.
Okay. Give me just a second. And are you Miss Owens?
Yes, I am.
Okay. You heard me read that stipulation of evidence, judicial confession, and disposition agreement with Ms. Walden. Do you also agree with everything in that document that I read to her?
Yes, sir.
All right. All right. Next one. Clause number 323-112447-19. Wait a second.
That's the motion to modify.
Correct. Should be 323-113494-20. All right. May it be agreed and stipulated between the parties in the above styled and numbered cause in which Micaiah Yvette Walden is the respondent the following facts. If the witness Denise Owens were in court and testified under oath, they would testify that they reside at a certain house number on Lincolnshire Way, Fort Worth, Tarrantcounty, Texas. They would further testify that they are the parent or guardian of the respondent in this cause, that the respondent's name is Micaiah Yvette Walden, a female child, 14 years of age, having been born on that date of birth you and I discussed earlier. The witness would also testify that they are the person who has the custody and control of the respondent in this case. Do you agree with that?
Yes, sir.
All right. Next paragraph. I, Micaiah Yvette Walden, the respondent in the above entitled and numbered cause, in writing in open court, consent to the stipulation of evidence in this case, and in so doing expressly waive the appearance, confrontation, and cross-examination of witnesses, the right to a trial, and the right to a trial by jury, and further consent to the introduction of testimony by affidavits, written statements of witnesses, and other documentary evidence. Accordingly, having waived my federal and state constitutional right against self-incrimination, and after having been sworn upon oath, I judicially confess to the following facts and agree and stipulate that the facts are true and correct. First numbered paragraph. I was born on that date of birth you and I discussed earlier, and I live in Tarrant County, Texas. You agree with all that I just read?
Yes, sir.
Next paragraph. Next numbered paragraph. On or about the 9th day of April 2020 in Tarrant County, Texas, I did intentionally operate a motor-propelled vehicle, namely an automobile, knowing that it says she, but it should you, did not have the effective consent of the owner, Tragic Walden. Do you agree with that numbered paragraph?
Yes, sir.
Third paragraph. Such conduct is a state jail felony and violates a penal law of the state of Texas, punishable by imprisonment or confinement in jail, to wit, section 3107 of the Texas Penal Code, and its delinquent conduct is defined by 5103 of the Texas Family Code. Do you agree with that?
Yes, sir.
Final paragraph. I, Micaiah Vet Walden, further agree and stipulate that I am a child in need of rehabilitation, or that the protection of the public requires the disposition be made. I stipulate that it is in my best interest to be placed outside my home. Reasonable efforts were made to prevent or eliminate the need for removal from my home. Reasonable efforts were made to make it possible to return home, and the quality of care and level of support and supervision needed to meet the conditions of my probation cannot be provided in my home. I further agree to a disposition of 18 months probation, placement at Lake Granbury, and any other orders of the court. Ms. Walden, do you agree with that paragraph?
Yes.
All right. Now, Ms. Walden, you understand by agreeing to all that, if I follow that plea bargain agreement, you give up one more very important right in both cases, and that's the right of appeal. That's where a different court, the Court of Appeals located in downtown Fort Worth, would look at what we did here today to make sure everything was done correctly. But if I follow the plea agreement, there will not be an appeal. Do you understand that? Is that a yes?
Yes.
All right. Sit back up for me, Ms. Walden. Sit back up for me. Sit up straight for me. Thank you. Now, the next two questions, the U.S. Supreme Court makes me ask of every kid who sits in that chair. Are you an American citizen?
Yes, sir.
Where were you born?
Fort Worth, Texas.
All right. Mr. Adeniji, you've gotten to know Ms. Walden for a while. Do you have any reason to believe that she does not understand the charges against her?
No, she does.
Do you believe she also understands what she's doing here and the ramifications?
Yes, Your Honor, she does.
All right. And counsel, I agree, based not just on my interactions with Walden today, but our previous interactions during detention hearings. She's a pretty bright young lady. And so I believe that she is competent. Does either side believe there are any additional admonishments that need to be given at this time?
No, Your Honor.
Nothing from the state.
Nothing from the
All right.
defense.
Ms. Walden, I will find that you did engage in delinquent conduct as alleged, more specifically, that you operated a motor vehicle in violation of Section 3107 of the Texas Penal Code. Such conduct would constitute a felony if committed by an adult and is considered delinquent conduct under the Texas Family Code. And that will be the order of the court. I further find that you did violate the conditions of your probation in your older case. As you pleaded true, the court will accept your pleas of true to those violations, and that will be the order of the court. We're back on the record in two cause numbers, 323-112447-19 and 323-113494-20, both styled in the matter of Micaiah Yvette Walden. We're here for a disposition hearing. Pursuant to Rule 201 of the Texas Rules of Evidence, the court takes judicial notice of the contents of the court's file, as well as all hearings over which the court has previously presided. We're here for a disposition hearing. Are both sides ready to proceed?
Yes, Your Honor.
We're ready, Your Honor.
All right, state.
Your Honor, the state would now like to enter what's been marked as Petitioner's Exhibit 1 and Petitioner's Exhibit 2. Both have previously been provided to defense counsel by the Probation and Placement Department. Petitioner's Exhibit 1 is the social history, and Petitioner's Exhibit 2 is the placement summary.
And Judge, we have reviewed both exhibits. I have no objection.
All right. With respect to Petitioner's Exhibit 1, Mr. Adeniji, do you have any additions, corrections, or deletions that need to be made there too?
No, Your Honor.
All right. Petitioner's Exhibit 1 and Petitioner's Exhibit 2 will be received and admitted into evidence. Who would the state call as its first witness?
The state would rest.
All right. Mr. Adeniji.
Judge, I will call Ms. Owens.
Ms. Owens, please look at the camera. Raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Before we proceed, I did forget to ask you, during the disposition hearing, you heard me read that second stipulation of evidence judicial confession and disposition agreement to Ms. Walden, correct?
Correct.
Did you also join her and agree with all of that?
Yes.
All right, thank you. Mr. Adenishi, I apologize. Your turn.
Judge, since you did that, I'd like also, for the record, on the new petition, we have the first amended petition. There are 2 paragraphs. But for the records, I want to be on the record that the state waived the 2nd paragraph.
And the state did waive the 2nd paragraph. We proceeded solely on paragraph 1.
There being no evidence submitted to substantiate paragraph 2, the court will find paragraph 2 in cause number 323-1134-94-20 to be not true.
Thank you, Judge.
All right, you may
I
proceed.
appreciate that. Yes, Judge. Ms. Owens, is there something, I mean, we have had discussions about these cases over the period Makia have been in detention. You and I, we have discussed about this case.
Yes.
And you have also discussed with the probation officer.
Yes.
And we have all kind of consulted about what's the best that we're trying to accomplish for Makia.
Yes.
And 2 days ago, I had you on the phone with Makia, and we went through what the judge just went through with Makia. Did we not?
That's correct.
And Makia asked some questions about what's going to happen at placement, at which point I called and joined the probation officer on that call.
That's correct.
So there were 4 of us on that call.
Yes.
And we all discussed about all the agreements we reached and about what we expect the court to approve those agreements.
That's correct.
And was there any questions that either you or Makia had that I did not answer?
No, you answered them all.
Okay. And of course, we all know that Makia would rather go home instead of placement, right?
Yes.
And we all try to impress on her that it's in her best interest, knowing, just like the judge said, TJJD or placement. And we all agree that in the circumstances, placement is the best option.
Yes.
Now, the judge has read everything we have agreed to. Do you have any questions about what we are doing has been in the best interest of Makia?
I don't have any questions. I just want Makaya to know that I do love her and I think it's in her best interest that she goes to placement at this time. We've utilized all of our resources that we have at home trying to help her through her situation. And I think this is the best decision for her and for her future.
And lastly, when we were talking, I believe Makia asked the question, how long is this, right?
She did ask how long. You did tell her it's based on how well she do in placement and her behavior in placement.
And did Makia not assure us that she's going to continue to do well as she's been doing in the detention center?
Yeah, she said she was going to do well and she'll do the minimum there because she's going to do that well.
Okay. No further question, Judge.
Ms. Bell.
Yes, Your Honor. Nothing from the state.
May this witness be finally excused by both sides?
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you, Ms. Owens. Who would Ms. Walden call as her next witness?
Ms. Walden or me?
No, sir. I don't think we can have you testify as a witness.
I'm calling Miss Walden.
Oh, okay, I'm sorry. All right, Miss Walden. Miss Walden, please face the camera. Raise your right hand for me. You solemnly swear or affirm that the testimony you will give in this cause is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Adeniji, I will allow you to qualify her first as a witness because she's under 16, and then proceed.
Thank you, Judge. Ms. Walden, do you understand the difference between telling the truth and lying?
Yes.
If you say today is Thursday, would that be a lie or the truth?
A lie.
If I say I'm a woman, would that be the truth or a lie?
A lie.
Okay. May the witness be determined to have been able to know the difference between the truth and a lie, Judge.
That will be granted. You may proceed.
Thank you, Judge. Ms. Walden, is there any question in your mind about the process we're going through right now?
I mean, I don't know, because I feel like I have reasons why I shouldn't go to placement.
Okay. Did you hear your mom testify a few minutes ago?
Yes.
Is there anything she said that is not true?
Everything she said was true, but
Okay. So we talked 2 days ago, first 3 of us, with your mom, myself, and you, then with the probation officer to answer some questions, correct? And yesterday, you requested to talk to me, and I called you, and I also spoke with you. Right?
yes.
Did you, when I asked you if you have any other questions yesterday, what did you say?
Oh, I said I didn't mean to request you because they asked me when I was asleep. So I was just like.
So you requested to talk to me. They sent me an email that you want to talk to me. I called to talk to you. And the first thing is you said was, oh, it was a mistake. You didn't mean to ask them to talk to me, right?
Mm-hmm.
And then we went on and talked about what we are going to do today again. Correct?
Mm-hmm.
So as at yesterday, everything the judge has stated and what your mom said is what we talked about. Right?
Yes.
And I did talk to you about the fact that I know your preference. You want to go home with your mom, correct?
Yes, sir.
And I told you the circumstances, the options are limited. And that's where we are. Correct?
Yes.
Okay. So do you have anything to tell the judge?
I mean, ever since I've been in detention since April the 9th, like I've been having time to think and stuff. But I feel like I've been doing well. And I've been on a level 1 status. And I feel like if I can do well in here, I can do out good in the community. But I mean, it's not my decision now. And like, it's like a lot of reasons why I don't want to go to placement. I'm not ready to be away from my mom or my brothers.
And did I tell you that how well you do in placement will determine how soon you come back home?
Yes.
And did you assure me and your mom that you are going to continue to maintain the level of conduct that has handed you level 1O outstanding in detention when you get there and be back home as soon as possible? Correct?
Yes, sir.
No further question, Judge.
Bell?
Nothing from the state, Your Honor.
May this witness be finally excused by both sides?
Yes, Your Honor.
Yes, Your Honor.
All right, who would Ms. Walden call as her next witness?
No further witness, Judge.
Rebuttal evidence from the state?
Nothing from the state. The state would rest and close.
All right, summation.
The state would just ask that the stipulated agreement be followed in this case.
Mr. Adeniji?
I agree with the state. I believe what we have agreed and presented for the court's approval is in the best interest of Mekia, considering all the circumstances of this case, which is well known to the court, that rehabilitation is what Mekia needs to continue to do the right thing. She has succeeded to do that, prove that in detention. I believe she will continue to do that in placement.
Rebuttal summation?
Nothing from the state.
All right. The court will note for the record that the court has reviewed the respondent's detention logs and how she has done in detention at least since May 5th of this year. She has been either level 1O or level 1A consistently. And Ms. Walden, you are to be applauded for that. That is not easy to do, especially given some of the things that have happened back in detention during the last month. The fact that your behavior has been extremely good, you are to be credited for that, okay? With respect to cause number 323-113494-20, I find that you are a child in need of rehabilitation. I further find that granting probation is in your best interest as well as the best interest of the community. I find that reasonable efforts have been made previously by the Tarrant County Juvenile Justice Department to prevent or eliminate your need from removal of the home and to make it possible to return to your home. And that at this time, your needs are such that it's not possible to send you back home right now. In order for you to successfully meet all the conditions of your probation, not just in this case, but the other case. And that you have certain issues or special needs that cannot be met with the resources available here. And so during your 18 months of community supervision in this case, I order that you be placed at Lake Granbury for such time as until they have determined that you have sufficiently been rehabilitated. I will waive all probation fees and I will waive all court costs in this case. I will waive any parental community work service. And as a reward for you having done so well in detention, normally I would order something close to 120 hours of community service for a felony case. But because you have done so well in detention, I'm going to waive any community service in this case. That is to reward you for behaving so well. I think you've earned that. Okay, with respect to your other case.
Judge, she wants to say something.
Yes, ma'am. Yes, Ms. Walden.
What does that mean? Like what you just rewarded me? Because I don't know nothing that means.
Okay. That's okay. That's a good question. Normally, for a felony case, I order the kids as a condition of probation to complete about 8 hours of probation, 8 hours of community service a month. And because you're going to be on probation for 18 months, that would be a lot. That would be over 100 hours. However, I have made the decision not to order any community service in your new case. And I'm doing that solely because you have behaved so well in detention that I think you deserve a reward for that. Does that make sense?
Mm-hmm.
Okay. Now, with respect to cause number 112447, the court will also follow the negotiated plea agreement in this case. The court will order an extension of your probation for 1 year placement at Lake Granbury. I will waive any additional court costs. I will waive any additional probation fees. And once again, because you have behaved so well in detention, I will waive any additional community service in this case. Anything else from either side?
Nothing.
Nothing from me, Judge.
All right, Ms. Walden, good luck. That'll be the order of the court.
Thank you,
Your
Judge.
Honor.
Thank you, Your Honor.
Appreciate it.
Thank you, Ms. Owens.
Thank you.
Thank you, Ms. Smiley.
Can I be excused, Judge?
Lateef, I'm trying to talk to somebody else right now. You're gonna have to wait.
Okay.
Sorry about that, Lateef. Had somebody who'd been
No,
waiting.
I was just asking if I can be excused.
Oh, I am so sorry. Yes. Do you not have any detention hearings today?
I don't think so, Judge.
Oh no! I look forward to your detention hearings. You fight. You fight for your
Thank you.
clients.
Well, I appreciate you, Judge.
All right. Have
Thank
a great day.
You too. Have a nice weekend.
Have a good weekend, Lateef.
You too, Judge. Bye.
Bye-bye. Okay. How many people did I have to kick out of the courtroom who tried to interrupt this hearing? And I'm not counting you. You had a very good reason. No, you had a good reason.
And I do have to say, this is the first hearing that we were all ready to go close to 8:30. And I was like, I don't know where Judge Porter is. So I apologize you didn't have notice.
That's okay. All right. See you later.
where that came from as far as county.
Are you Mr. Barber?
Yes, sir.
We've got about 8 minutes before we get started. Do you want to have a chance to talk privately with your attorney, Mr. Shaw?
Yes, sir.
Judge, I'd like to speak to it.
All right. Just try and keep it to less 5 minutes or less.
Yeah. No worries.
Hold on.
Hey, Mr. Shaw.
All right. You should get the invitation.
Go ahead and click on that.
And Judge Porter, good morning.
Good morning.
It's David. Just want to verify that we are going in alphabetical order A to Z today.
Yes, because I didn't get the memo to y'all in time, so we'll go ahead. Mr. Barber's already set up anyway.
Okay, sounds good, Judge.
That's 5. There are only 5 of them anyway.
True,
So,
should be pretty quick.
yep.
Diplomatic and military.
Full screen. This is my turn. You gotta exit full screen and put like the actual. Yeah, go right there. At the top. Exit full screen.
Hey, Larry,
Yes,
just want to make sure you know the last one is under 14, right?
that's correct.
Okay, just making sure. Thank you, sir.
Hey, George. Okay. He go.
I guess next week we'll start going through cases again this beginning of the month. Yeah, so I just went through and updated my docket with all the changes from last week. Yeah, I need to figure out transportation. On that, I'm gonna see it before I leave. I'm normally committed to going to pick that kid up tomorrow.
All right, are you Mr. Barber?
Yes, sir.
All right, my name is Judge Porter. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not blurt it out. Instead, I want you to wave your hand like this. That'll get my attention. That'll also get the attention of Mr. Shaw. He's your attorney. And I will create a private internet chat room for the two of y'all to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense? Is that a yes? Is that a yes?
Yes, yes, sir.
All right, I need you to answer out loud for me. All right, pursuant to the order of the Texas Supreme Court, the physical courthouses are generally closed to the public, except for family members and things like that. However, in keeping with the open courts provision of the Texas Constitution, this hearing is being broadcast on the court's YouTube channel. Because you have the right to remain silent, I also need to let you know that anything you say at this hearing cannot be used at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. So, Ms. Turner-Hill.
Yes, sir.
What brings Mr. Barber back to court today?
This is his 10-day detention hearing, Your Honor. He was referred in custody on May the 14th by White Settlement Police Department for a DTA that was issued by the court for EM violations. According to the certifications, Jacob had an EM violation on March the 28th, where he was out from 11:06 p.m. to 3:02 a.m. Then on March the 29th, where he was out of the home 3 separate times from 3:56 p.m. to 4:24, 4:42 p.m. to 8:20 p.m. and 10:20 p.m. to 10:41. I called his mom on April the 2nd to discuss the violations with her. And she said that she felt like Jacob was taking the electronic monitor as a joke and she reported that he would often leave home without permission. This is his second violation on the electronic monitor. He turned himself in on March the 8th after having violations as well. Jacob is pending a robbery charge that allegedly occurred on December the 24th, and also a criminal mischief charge where he was referred out of custody. He's scheduled for an adjudication disposition hearing on June the 8th. And when he came in on the 15th, his UA was positive for marijuana, and Jacob is level 1 outstanding as of yesterday. His mom couldn't be here today because of her job. She works at a hospital, but she is willing to accept custody of him if the court decides to release him.
Mr. Shaw, what are your thoughts?
I was going to ask Ms. Turner-Hill, how many days has Jacob been on level 1?
He just got on it yesterday. Prior to then, he went from level 1 to level 1 acceptable, just back and forth every couple of days.
And his mom said she'd be able to pick him up today if he were being released by the court?
Yeah, she doesn't get off till like 4, I think. It would be this evening.
And did she also indicate to you that she would be able to bring him back to court on not this Monday, but the following Monday for our trial?
She did want to talk to you about changing the appointment, just because she wants to get it scheduled, or the court hearing, on a day when she's already off of work because of she's required to be at the hospital.
Okay. Okay. Well, that's a different issue.
Yes.
Judge, I would ask that my client be allowed to go home with his mother today. And I don't know about rescheduling the hearing, what y'all are doing about that, whether you're all even having in-person hearings on the 8th or not. But I believe I remember speaking to her before, you know, her job's important to her because I believe they've had some housing issues as well. And so I don't know, it's whatever we can do as far as we can reschedule that, that's fine. If we want to have to stick to that date, that's fine too, as far as I'm concerned. But I'd be willing to talk to her to see if we can maybe accommodate her schedule if you would, you know, allow my client to be released.
With respect to rescheduling the June 8th hearing, I will allow you and Ms. Farmer to discuss that with the court coordinator and make those arrangements if necessary. With respect to whether or not Mr. Barber should continue to be detained or be released to a parent or guardian. Mr. Barber, I believe that you still haven't proven to the court that you can follow the rules in the back, because you still can't maintain level 1.0 consistently. And the fact that you think EM is a joke means that you've got a ways to go to prove that you can behave accordingly. So, because I believe if I release you today, you would be a danger to the public, you will be detained. That'll be the order of the court.
Thank you, Your Honor.
Hey, Waffles.
I couldn't find any detention notes.
All right.
Probation officer, here's the judge, prosecutor, and then others.
Okay. Help me pronounce your last name correctly.
Barcenas?
Barcenas?
Yeah.
Okay. Are you Mr. Barcenas?
No, I'm the sister.
Well, I'm trying to talk to the juvenile.
Oh.
Are you Mr. Barcenas?
Yeah.
Okay. I need you to pull your chair closer to the computer. I need you to sit up straight. And when I ask you a question, I need you to answer out loud, okay?
Yes, sir.
All right. And I need you to speak up a little bit. All right. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. You have the right to an attorney. The court has appointed you an attorney, Mr. Adler. Do you see Mr. Adler on the screen?
Yeah. Yes, sir.
Okay. You have the right to remain silent and not say anything at all. if there is something you want to say, please do not just yell it out. Instead, move your hand like this. That'll get my attention and Mr. Adler's attention. I'll create a private internet chat room for the two of y'all to talk about what you want to say. That way, Mr. Adler can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
Okay. Anything you say today cannot be used against you at an adjudication or disposition hearing, but it can be used against you at a future detention hearing. Do you understand that?
Yes, sir.
All right. Mr. Neva, what brings Mr. Barcenas to court today?
All right, Judge, gentleman was brought into custody yesterday by Fort Worth PD for assault, bodily injury on a family member, specifically his sister, who is present here today. According to the report, around 9:40 in the afternoon, the officers were called out regarding domestic. They spoke with the victim, his sister, and she said that she found a small amount of marijuana in her brother's room, and she confronted him about it. Her brother raised his voice, and then she raised her hand to attempt discipline, but she was, it states that she was bluffing, and that's when her brother punched her on the left side of the face. She's also pregnant, and she was taken to JPS to get checked out. She also did want to fill out a form of a declaration of non-prosecution, and she did fill that out. And mom told me that as he was attending TYRC outpatient, I think currently they were just doing phone contact, but she does wish for him to be there, and they're doing that on their own.
Okay. And does mom want Mr. Barcenas to come home today?
I can ask her, Judge. Mamá, lo he preguntado, ¿usted quiere que Germán regrese a la casa con usted hoy?
Pues si hubiera la manera de poderlo ayudar un poquito más, me gustaría que le buscaran un lugar.
Mom said that, pero la pregunta es si lo quieres hoy, que regrese a la casa o no.
Pues
sí o no.
No.
This is not good.
Ya la posibilidad de mejor que lo tratan de ayudar desde hoy, está bien.
Okay, we also spoke beforehand. I'm guessing what she's telling me, she wants us to try and help him out. He does have substance abuse issues in the past, and I've told her that we could possibly TYRC, but we don't have a guarantee that he can be accepted there. But if they're doing that on their own, that's already helpful. But what she told me beforehand, that she just wanted to stay at least for a couple of days so he can learn from this experience.
Mr. Adler, what are your thoughts?
Well, Judge, I guess clearly he wants to go home, but you saw what I saw, Your Honor. The mom is hesitant. So maybe if you're inclined to keep him, I can ask for a detention hearing before the 14 days is up if mom has a change of heart and visiting with the young man. So I would just defer to her wishes and your wishes at this point, Judge.
All right, Mr. Barcenas, you don't have a parent or guardian who wants you to come home today. However, what I want you to do is get to level 1-0. Have they explained to you what that means?
Yes, sir.
Okay. We have 3 different levels of behavior in the back. Level 1, level 2, level 3. Level 1 is the best. And then within each level, there are different degrees. Level 1 is acceptable. 1A is acceptable, but level 1 is outstanding. That's the absolute best. I want you to get to level 1-0, and then you can be released to your mom and you can get to go home. But you got to work your way up to level 1-0, okay? Once you do that, then that will prove to me and prove to your mother that you can follow the rules. And once you get to level 1-0, you can go home. And I expect you to maintain level 1-0 at home too, okay?
Yes, sir.
All right. Will that work, Mr. Adler?
Yes, sir. That's fair. Thank you.
All right. That'll be the order of the court. Thanks, y'all.
Thank you, Judge.
Make sure you speak up for everything.
He has no history. Well, he does, but He has no adjudication history with us.
Your Honor, are you able to hear me?
Are you Mr. Beasley?
Yes, sir.
All right, Mr. Beasley, pull your chair just a little bit closer to the computer for me. Thank you, sir. All right, this is a detention hearing to determine if you should be released to a parent or guardian or ordered to remain in detention. My name is Judge Porter. You have the right to remain silent and not say anything at all. If there is something you want to say, please don't just yell it out. Instead, I want you to move your hand like this. That'll get my attention. That'll get your attorney's attention. Your attorney's name is Frank Adler. Do you see him on the screen? Okay. And I also need you to answer out loud when I ask you a question, okay?
Yes, sir.
All right. If there's something you want to say, wave your hand like that. That'll get my attention. I'll create a private internet chat room for you and Mr. Adler to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
Anything you say today cannot be used against you at an adjudication or disposition hearing, but it could be used against you at a future detention hearing. Do you understand that?
Yes, sir.
All right. Mr. Thomas.
Yes, Your Honor.
What brings Mr. Beasley to court today?
Yes, Your Honor. On Thursday, May 28th, 2020, client William Beasley was referred in custody by the White Settlement Police Department for the offense of evading arrest and harassment of a public servant. According to the police reports, officers were conducting a general investigation in the 400 block of Meadow Park. They identified themselves as police officers and were wearing full uniforms. As officers approached the male, later identified as William Beasley, he proceeded to run. Mr. Beasley then jumped several fences. Backup officers were called to the scene, and after a brief chase, a client was captured and placed in handcuffs. As officers went to help client to his feet, and while facing officers, William Beasley proceeded to spit on the officers, hitting one in the face and chest area. Client was then arrested and taken into the White Settlement Police Department's juvenile room and later transported to Tarrant Juvenile Detention Center. In addition to this offense, Your Honor, as of May 18th, client is also pending an offense of assault causing bodily injury that was referred out of custody to the department. The young man is currently on probation for an unauthorized use of a motor vehicle and assault causing bodily injury and was placed on probation back in February 24th of 2020.
And was that adjudication disposition hearing back in February? Was that in front of me?
I believe it was, Your Honor.
I remember, Mr. Beasley. All right, what says the state?
Sir?
Ms. Bell, what says the state?
Your Honor, based on the respondent's prior adjudications, I believe that if he was released, he would be likely to reoffend. So that's the state that he should be detained.
Okay, Mr. Adler.
Judge, I think I saw the parent there. Can I ask her some questions?
Yes, it's the older Mr. Beasley and Ms. Humphrey, correct?
Yes.
Okay, so you have your pick of mom and dad.
I'll start with Ms. Humphrey. Does he live with you, ma'am?
Yes, sir.
And who lives in your house?
Me and his 4 other brothers.
And I'll just start with this question outright. Do you want him to come home today?
Yes.
And if the judge releases him on the ankle monitor to your house under strict house arrest, what would the supervision look like?
He's gonna be inside.
And I guess that was a bad question. My apologies. Ma'am, are you working right now?
I'm not.
So would you be home with him the entire time?
Yes.
And if he stepped outside or violated that EM, you would call Mr. Thomas?
Yes.
And what was he doing out this time that caused him to come back yesterday, I think? Do you know?
No, we're not sure. We thought he was just hanging out with friends and riding bikes.
Other than this offense, has he been behaving since he was put on probation by Judge Porter in February?
Yes, sir.
He has.
So he's been doing everything except this violation?
Yes, sir.
Okay. Thank you. No further questions, Judge.
Mr. Thomas, was a violation of court order for technicals filed in May 18th of this year?
That is correct, Your Honor.
And what were those alleged violations?
That alleged violation is the assault causing bodily injury. That's still pending due to the COVID-19 situation we have not been able to paper formalize the referral at this point in time.
All right. Anything else from either side?
No, Your Honor.
No, Your Honor.
Yes, sir. Mr. Beasley, you have something you want to say, or Ms. Humphrey, you have something you want to say?
Yes, I do. About the case he's talking about the assault with bodily injury, that, I mean, he just said that he haven't had time to investigate it or whatever, but I've been in contact with this lady and she's like somebody that we know pretty well, and she's saying that it was all a misunderstanding. Her husband just was upset about the situation. So she said she was going to try to do what she can to get that dropped or whatever from him, because she's somebody we really know, and they were just playing and her husband didn't think it was funny.
Okay. Well, then I will not factor that into my decision. However, the fact remains, Mr. Beasley, that you ran from the cops and was pretty disrespectful to have allegedly spit on them. You'd be pretty upset if the prosecutor came up to you and spit in your face, wouldn't you?
Yes, sir.
All right. So here's what we're going to do. I think if I were to release you today, you would not have learned a lesson. But I'm going to give you a chance in the back. You get to level 1-0. You maintain level 1-0 in the back for 5 days, and then you can be released to a parent or guardian. So if and when you get that out, that's up to you at this point, okay?
Yes, sir.
All right, that's the order of the court.
Thank you, Your Honor.
Correct.
Just pull the shirt up to the table, all the way to the table.
The judge is on the top right, and we'll start in just a second.
You, Mr. Carrera?
Yes, sir.
All right. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. My name is Judge Porter. You have the right to remain silent, not say anything at all. If there is something you want to say, please do not just yell it out. Instead, move your hand like this. That'll get my attention. That'll also get the attention of your attorney, Mr. Adler. Do you see Mr. Adler on the screen?
Yes, sir.
All right. If you want to say something, let me know. I'll create a private internet chat room for you and Mr. Adler to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
Anything you say today cannot be used against you at a future adjudication or disposition hearing, but it could be used against you at a detention hearing. All right. Ms. Cook, what brings Mr. Carrera back to court again?
Your Honor, this is Brian's 10-day detention hearing. He was referred in custody by Arlington Police Department for 2 charges of aggravated robbery and theft of a firearm on April 15th. According to the report, officers had responded to a call of a convenience store that occurred on April 14th around 2300. Officers spoke to the victims, who advised they observed 4 Hispanic males enter their business to commit theft and then fled on foot. While running away and in a parking lot, the primary suspect, which was not Brian, reached towards his waistband and made a motion to the victim like he had a gun concealed. And then another suspect intentionally pointed a handgun at the victims and pulled the trigger, which did not fire a round. This was later determined to be Brian based on his clothing, as well as the video and the victims. The victims stated they feared for their lives. The incident was captured on surveillance and they provided descriptions. Brian matched one of the descriptions, and officers, knowing Brian from previous cases, were able to identify him. They went to his home and first observed Brian and his father leaving the vehicle where the handgun was found when they arrived on scene. Brian's father initially said the gun was his, and he was then arrested for theft of a firearm, unlawful carry of a weapon, and tampering with evidence. At the police station, Mr. Carrera then changed his story, saying that Brian had asked him to come pick him up, and when he got in the car, he put the gun under his seat. He did not know that Brian possessed a gun. Brian was then transported to JPD without incident. He is currently on probation, which was going to expire actually today, for evading arrest detention. Brian, since being in detention, when he came in, I will say he did test positive for benzodiazepines and marijuana. Brian currently has a hearing set before you for an adjudication and modification on Monday, June 1st. However, ADA Williams had stated he was planning to go to the grand jury for a determinate sentence, and we don't have anything on that yet. I will say I staffed his case before the Resource Staffing Committee on May 13th, and the recommendation was placement. I found out about 30 minutes ago that Brian has been approved for placement in Iowa.
All right, at Clarinda?
Yes.
Okay. And are you Ms. Mendez?
Yes.
Ms. Mendez, do you want Mr. Carrera to come home today?
Yes.
Or are you afraid that he might be a danger to himself if I were to let him go home?
Yeah, yes, that's fine. And my phone is fine.
Okay. Mr. Adler?
Judge, I know mom's work, so can I ask her some more questions?
Please.
I'm just first going to ask her if she wants me to speak to her in English or Spanish. I usually speak to her in Spanish.
That's fine.
Okay. ¿Quieres que te hable en español o en inglés?
También es en español, entender mejor las cosas.
Okay. I'm going to speak to her in Spanish, Judge, and then I'll translate.
That's fine.
Si el juez deja que Brian vaya a la casa hoy, ¿quién va a estar ahí para supervisarlo? I asked her if you released him today, who would be at home to supervise him?
Yo trabajo de las 7 de la mañana a las 3:30.
¿Y quién va a estar en la casa de las? Well, her answer was she works from 7 to 3:30, and then I'm going to follow up. ¿Y quién va a estar en la casa si no estás ahí usted? And who's going to be in the house if you're not there?
No va a estar solamente él y Brianna, porque su papá trabaja también.
It's only going to be Brian and Brianna, who's a sister, because his dad works also. I have no further questions, Judge. I'll pass the witness to Ms. Bell if necessary.
Okay. Mr. Carrera, this could have easily been a capital murder case.
Yes, sir.
The gun had gone off. And then this would be in a totally different situation. I also see an escalating pattern of violence because you started out with misdemeanors and now you're ending up being charged, hadn't been proven anything yet, but charged with a first-degree felony that could have been a capital murder. And so this is just way too scary. I believe that based on this escalating pattern of behavior, that if I really release you, you would be a danger to the public. And so for that reason, I cannot do that. I must order that you be detained.
Yes,
So
sir.
that will be the order of the court.
Thank you, Judge.
All right. Don't bring the next kid up, please. Pursuant to 5408 of the Texas Family Code, the court will now be closing the hearing to the public. The remaining child or children are all under the age of 14. And so the law does require that we not broadcast their faces